Welcome to the Supreme Court of the United Kingdom. Today, we are hearing an appeal in the case of Triple Point Technology Incorporated, an American company, and PTT, Public Company Limited, company based in Thailand. The case raises questions of the interpretation of a contract which is governed by English law. Triple Point breached their contract for the provision of software and software implementation services, and PTT has claimed damages for breach of contract. Questions have arisen about the interpretation of a clause in the contract providing for liquidate damages and another clause imposing a cap or caps on Triple Point's liability in damages. Details of the appeal can be found on the court's website if you click on Cases and then go to Current Cases. I will introduce the justices hearing this appeal. I am Lord Hodge and am presiding today. With me is Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
Today, the appellant, PTT, is represented by James Howells, QC, and Nicholas Maciulek. The respondent, PTT, is represented by Andrew Stafford, QC, Paul Darling, QC, and Nathaniel Barber. I will now invite Mr. Howells to make his submissions.
Thank you. My lords, good morning. There are three grounds of appeal relating to two clauses in the contract, as my lord identified. I propose to take each ground in turn in the order they've been addressed in the appellant's written case. The first ground of appeal in the appellant's case is that the Court of Appeal erred in its construction of Article 5 of the CTRM contract and found in finding that the appellant's contractual entitlement to liquidated damages only arose in respect of those works which the respondent completed under the terms of the contract by reference to the agreed contractual milestones. In respect to this part of the appeal, I propose to adopt the following structure unless your lordships direct me otherwise. I will take this in four parts. Firstly, I'll give a brief review of the salient facts and the context of the issue. Secondly, I propose to review the approach taken by the Court of Appeal in its categorisation of previous cases and the identification of the general principle of construction in respect to what it called Category 1. Thirdly, to address the Court of Appeal's application of Category 1, the Category 1 principle, to the words of Article 5 in this contract. And finally, in my fourth part, I propose to pick up a few miscellaneous points that are raised by the respondent's written case. So, just brief facts and salient background. The CTRM contract was entered, as your lordships will have seen from the Statement of Facts and Issues, and from both of our written cases, for the development of a commodities trading, risk management, hedging, charter party and refinery management system based upon the development, tailoring and configuration of three proprietary software platforms owned by Triple Point. The implementation project itself was to last up to the go live of the system when it went into live production, plus 1 month of support, during which time all business consultancy services, system design, development, user training, and testing of the new system prior to its live use was to be accomplished, and that was to be completed within the first 460 days of the contract. The parties agreed the price to be paid for that work on the project, that part of the project, would be made by way of percentage lump sum percentage milestone payments linked to the completion of stated parts of the implementation works. Those milestones and the percentages were set out in Article 18, the payment provision, and the parties' agreements as to the dates for the relevant completion of milestones were set out in the agreed project plans, and those are set out for your lordships in the Statement of Facts and Issues. You'll find those at pages 9 to 12 of the bundle. It's common ground that only payment milestone 1 for the Phase 1 project was achieved, and that was achieved by agreement between the parties on the 19th of March 2014. It was late. By the time the appellant terminated the CTRM contract a year later, The respondent had failed to complete any other milestones and had been refusing to work on the project since May 2014. All of the contractual milestones by that date had passed. The exact process of the construction of the words that the Court of Appeal adopted are dealt with briefly in paragraph 112 of the Court of Appeal's judgment, and I'd like to look at those in due course.
Mr. House,
the construction...
Sorry, Mr. House, when you are referring us to documents, if you could give us the electronic bundle number, because several of us will not be working from paper, but will only have the material on our screen.
My apologies, certainly. I was going to come back for that.
Just for future reference, thank you.
Thank you. 156 is the page for this one, though, which is paragraph 112. The construction the Court of Appeal adopted was set against a backdrop of the Court's review and categorisation of earlier decisions where there had been discussion of liquidated damages clauses in the context of discharge of the contract. And the Court described this at paragraph 76, which your Lordships will find at page 149 of the electronic bundle, as an issue of general principle. There were no relevant findings by the trial judge at first instance, and that's because the respondent hadn't pleaded this case in its pleadings. It wasn't argued at trial that by the respondent that there was no entitlement to liquidated damages under Article 5 unless the works were completed. The argument was introduced for the first time in the respondent's written grounds of appeal to the Court of Appeal, where it was the appellant, and introduced in the skeleton argument to the Court of Appeal as a straightforward point of construction. It was not elaborated in triple points oral argument. The Court of Appeal intervened during PTTs, that is my oral argument, on other issues, and I'd asked for identification of cases where the courts had considered the impact of liquidated damages clauses, as the Court of Appeal alluded to. So it's a slightly odd beginning to this sort of part of the case. What I propose to do, though, is to look at the Court of Appeal's approach in two parts, and that is the categorisation and then the application of the categorisation to the clause in question. The respondent seeks to portray the Court of Appeal's approach as no more than the construction of the words of a bespoke contract, but the appellant suggests that's clearly not what the Court of Appeal saw in this point. The importance of this point, as identified in paragraph 76 of the Court of Appeal's judgment, comes from the approach the Court of Appeal took to drawing upon and categorising certain earlier decisions of the courts of England and Wales and other jurisdictions. The approach, as the Court of Appeal expressly said, was intended to set out a statement of principle for the construction of liquidated damages clauses and to apply that categorisation to the construction of the clause in the present case. The respondent suggests in its written case, as its first point, and this is paragraph 65 on page 106, that this may be...
I'm sorry to interrupt you, Mr. House. We're getting a little bit of interference. Can I ask my colleagues to check that their computers are on mute, please?
Should I proceed?
You can continue now, thank you.
The respondent's first point is in paragraph 65 of the written case, page 106, is to suggest the argument for the appellant may be about whether it's open to parties to agree to make any entitlement to liquidated damages subject to a suspension, so they may not arise until completion or may not apply if there is a termination early. But that's not the point here. It's clearly open to parties to agree in their contract any of those outcomes. The question arising on this appeal, the appellant says, is how to construe a contract when that is not made clear by the words of the parties' agreement. Should a court interpret a clause which does not expressly say so, to the effect that the liquidated damages do not accrue at all until there is actual completion, or that any accrued right is extinguished if the contract is discharged or terminated prior to that actual completion? The appellant says the answer to that question is, based upon general legal principles, is no. A further point arises, the appellant suggests. Given the Court of Appeal's approach to construction was to consider those principles construction of the clause of liquidated damages clauses by undertaking a categorization of earlier cases, is that itself correct? Contract this. And to that, the appellant also says the answer should be no. The Court of Appeal's suggestion that Glanstoff or the Category 1 cases might be binding on other courts deciding the construction of other contracts using similar wording is not the correct approach to construction, we suggest. The correct approach to construction is to take the words of the contract in their factual context and construe them on that factual context. The respondent says that because the Court of Appeal decided it was not bound by Glanstoff, but only that the wording was sufficiently similar that the clause fell into the same category, the Category 1, which the court had identified, like those clauses in Glanstoff, Chantal and F.M. Minter and Gibbs and Tomlinson, the Court of Appeal's interpretation in Glanstoff is effectively irrelevant to this appeal. And the appellant says that's not correct either. It ignores the process of reasoning the Court of Appeal adopted. It also ignores the extensive and lively debate the Court of Appeal's judgment has engendered in the construction, project and IT industry since March of 2019. The appellant suggests, respectfully, it's unrealistic to suggest that the judgment and the approach taken by the Court of Appeal is irrelevant to the future construction of liquidated damages clauses and the potential for the decision to foment disputes as parties seek to argue whether a clause in question in other contracts is properly within Category 1, 2 or 3. So with that, maybe I could look at the approach the Court of Appeal actually took to the principle of construction, categorization. Described as a point of principle, as I've said, the Court of Appeal started by reviewing the House of Lords decision in Glanstoff. And for that, my lords, if I could ask you to turn in the Court of Appeal decision, it's a number of paragraphs. I'll give them to you. The essential point here is the one I'll come to at the end. The paragraphs in the Court of Appeal judgment in the bundle, you'll find at paragraphs 87 to 89 on page 151. And again, largely repeated, paragraphs 102 to 109 and 112, and those you'll find pages 154 to 156, the electronic bundle. And in summary, where they get to, what we've got to was to conclude the decision of the House of Lords in Glanstoff was that the liquidated damages clause in that case would not apply when the contract was terminated before actual completion, physical completion of the works by the original contractor. The Court of Appeal said that would have been the case even if the contractual completion date had passed and liquidated damages would otherwise have accrued. And the point which I'll come back to is that on the fact of Glanstoff, the agreed contractual completion date had not passed. The termination of the contract took place before the contractual completion date. The original contractor, Brown, was, in the words of the House of Lords, as we'll see, ousted and replaced by a contractor called Henshaw. Henshaw undertook and completed the works, and the liquidated damages claim was based upon an assertion that the calculation of damages should be made by reference to the date on which Henshaw finished the works. Now, we're going to look at the House of Lords decision in Glanstoff, if I may. The appellant says the Court of Appeal's interpretation of the Glanstoff decision in the House of Lords and in the inner house of the Court of Session, which we'll look at as well, is based on a misapplication of the reasoning and decision of both those courts. If I may take you first to the House of Lords decision, you'll find that in the bundle. It starts at page 820. I think it's called like.
Sorry, Mr. Howells, I don't want to take you out of your way, but one of your contentions is that we ought to be construing this particular contract, and that's the primary task of the court. I'm not quite sure why you don't have the courage of your conviction and actually take us to the clause before we start looking at different wordings in other cases. But I mean, if you think it's more helpful to look at other wordings first and then come around to this one, so be it.
Well, I'm happy to ask. If we look at the clause then of this contract, Article 5.3, you'll find at page 741 of the bundle. Article 5 is in three parts. We've been referring to the relevant part as 5.3. It refers to the unnumbered third paragraph in Article 5. And as your lordships will see, the wording there says if the contractor fails to deliver work within the time specified, or delay has not been introduced by PTT, the contractor shall be liable to pay the penalty at the rate of 0.1% of undelivered work per day of delay from the due date for delivery up to the date PTT accepts such work. Provided, however, that if undelivered work has to be used in combination with or an essential component of the work already accepted by PTT, penalty shall be calculated on the full cost of the combination. And the appellant says that the wording on its plain English words identifies, as is common with many damages clauses, a start point, identifies that the commencement of the liability is from the due date. And its common ground on the due date here refers to the date agreed by the parties to be the relevant milestone date set out in the relevant project plan, which your lordships have at the statement of facts and issues. There's from the due date up to the date PTT accepts. The appellant says what that does, it sets a start date from and sets an end date or a period over which one calculates liquidated damages, in the words up to meaning effectively up until. And what the clause does is sets out a start point, a period, and sets effectively, like in common with most liquidated damages clauses, although in different words, the end point at which the point at which the calculation ends.
The nub of your point, Mr. Howells, I think the nub of your point is that the clause sets a start date and end date, but it doesn't set a trigger for accrual at the end date.
Absolutely. The interpretation of the Court of Appeal effectively imposes a second threshold. Yes. Says you don't. There's some difficulty we suggest in quite what the Court of Appeal was saying about the clause, because the nature of how the Court of Appeal described the accrual trigger. Yes. I think for the better view is the Court of Appeal was saying the trigger doesn't occur until the acceptance point, the completion point.
Yes, and yeah, your submission is that one should not read into the words that you've referred us to an intention that the accrual starts only if the termination date is achieved, namely acceptance. Yes,
absolutely. By triple itself, which is the point the Court of Appeal were extracting from the Glansoff decision, which is sort of why I was trying to go with the Glansoff approach. But that is it in a nutshell. There are other pointers, we say, as to why where the Court of Appeal got to with the construction of the clause was incorrect, because the essential result of Court of Appeal's interpretation is that there is either because there's no accrual at all, or because any accrual is extinguished on early termination. 2 points. One, there was no need to introduce through construction into the clause a mechanism to deal with early termination, because the English legal principles provide that. On early termination, liquidated damages as a contractual remedy, that is effectively the primary obligations as described by Lord Diplock in photo production, end, were replaced by secondary obligations in general damages. So the accruing entitlement to liquidated damages as a primary obligation expressed as a payment obligation would end on termination. That's English law. You don't need to insert anything to deal with that issue. Taking the approach that the accrual date requires a second threshold, one introduces real problems for the reasons we've given, which is that what happens here is when you combine the liquidated damages with the limitation clauses, and you end up in a situation where there is no entitlement to the damages at all. So what happens is, well, actually, it doesn't have to be combined with the limitation clauses. It's the effect of the clause itself. Is that if you cannot incur, if there is no accrued right or accrued obligation to pay liquidated damages as expressed by this clause until you achieve completion, what happens? What will happen is you've incentivized triple point not to complete if necessary, because they will have no liability in liquidated damages unless and until there is completion. And that's as true of the first milestone as of any milestone that follows. So what you end up with is a situation where triple point effectively is given the opportunity to, effectively through the operation of this clause, limit its liability, delay as it did, as the judge found, and have either no liability if it doesn't hand over the first milestone pack work, or anything else that follows. The other pointer we say is actually in the words of Article 5.3 itself, and it's the last part that I read out. It's the last, effectively, it's the proviso in the last 2 lines or so. It identifies that the calculation of liquidated damages in certain circumstances itself is based upon a calculation of not just the delivered work, but undelivered work as well. When there's a link between the two, and we say, well, the essential concept of the Court of Appeals that underlies the Court of Appeals construction is you only look at what's delivered, and then you get to work out what your LDs, liquidated damages are. That clause actually says you have to understand not just the value of the delivered work, but the value of the undelivered work, and the two are not consistent. We suggest it points towards the clause being construed in what we would say is category 2, or what the Court of Appeal described as being the usual orthodox approach to things.
Lord Burrows has a question.
Yes, can I just be absolutely clear what your submission is about this clause? You're not suggesting that we read in delivery up to the date PTT accepts such work, or the contract is terminated by PTT?
I don't know, because I don't think you have to read that in. I think that's the effect of photo production.
Yeah, but what I'm trying to get at is that is the effect that you wish to produce. But as I understand it, you are saying there's no need for people drawing up a contract to actually insert such a provision because it's the general law in any event. Is that the submission?
Absolutely, yes.
Lord Leggett.
One way of testing your point, Mr. Howells, it seems to me, is to ask, what's the position if, after, say, 6 months of delay, the PTT decides to put in an invoice for liquidated damages? Is there any reason why it can't do that? And on the face of it, that there's nothing in the clause that suggests it can't, is there?
No, absolutely. And this is actually one of the points I was going to come to on how we suggest the respondent's approach to dealing with that construction clause is wrong, because there are 2 aspects here. First is the obligation imposed by Article 5, which is that is the liability for liquidated damages imposed by Article 5 on triple point, on the contractor, and that is not linked to invoices at all or payments. It is a liability which is said to accrue from the due date, and we say up until that is for that period. My own friends say in their written submissions, particularly in paragraph 79 of their written case, one has to look at the payment provisions of this contract, Article 18, which your lordships will find, starting from Article 18 starts at 749 in the bundle. And what it broadly provides, what it effectively provides is you the contractor, Triple Point, is entitled to invoice for its works at the point of acceptance. So you're entitled to invoice only at the milestone point. And so that indicates that the construction of the contract, construction Article 5 by the Court of Appeal is right, because you only get to invoice for the milestone when it's accepted. And they point to the word acceptance as being the link, I think. But what that doesn't deal with, it seems to me, and what that elides are the two separate points. It elides the liability in Article 5, the liability for liquidated damages, which can be sued on, with a reference in Article 18, which is I think the reference given, the one that's relied on particularly, which is 18.3. Start at the bottom 749, over the page 750. It's the second part of 18.3, which deals with the obligations of PTT, the employer, to make payment, and the entitlement of the employer to deduct the penalty, to deduct liquidated damages from any payments. Of course, the two are not the same. So come back to my Lord Legate's, you do put an invoice. As long as I'm talking about the Triple Point invoice, and there's no suggestion that what we're talking about in an invoicing system of payment, and then the answer is yes, PTT can claim liquidated damages at any point. It doesn't have to wait until Triple Point achieves completion or acceptance. It can claim them, and Triple Point has that liability. It may, of course, it's also use the self-help remedy of deduct liquidated damages from any payment against an invoice under 18.3, but the two are separate.
Thank you.
Thanks.
I briefly made the point about the last part, the proviso to Article 5.3, which is, we say, inconsistent with the idea that there must be acceptance or completion before, and because in the sense the LDs, the liquidated damages have to be referenced to completed works at that point in time. If I may, I was going to now loop back to where I was and look at the Glanstoff.
Yeah, yes, take us through the Court of Appeal's reasoning and your criticism of it. Thank you.
Thank you. So for that, it's the House of Lords decision in Glanstoff, which started at page 820 in the bundle. To note, the House of Lords commenced giving their speeches at the conclusion of the appellant's argument at the bottom of the head note, so without hearing from the respondents. But the relevant part starts in the speech of the Lord Chancellor over the page, on page 821, the first main paragraph where the Lord Chancellor describes the relevant clauses, in particular clause 24-26. As your Lordships will hopefully be aware from our written submissions, that what the appellant says, the key to this case is to understand the relationship between clause 24, which was the liquidated damages clause, and clause 26, which was the clause which dealt with the entitlement of the employer to oust the original contractor, have the works completed by somebody else, and then claim the costs of that from the original contractor, subject to architect certification of the reasons of those costs. The Lord Chancellor deals with that on page 821. The reasoning, which is key to what the Court of Appeal said in this case, starts on 822 on page 3. So he identifies the claim is made against the insurance company who stood behind, that is General Accident, who stood behind Brown, and says, starting from the top there, I would like to pick up, if I may, halfway through the paragraph. In my opinion, does not apply. I think it doesn't apply for 2 reasons. So he's dealing now with clause 24, which is the liquidated damages clause. It doesn't apply for 2 reasons. The first is it's inapt altogether, the provisions made by clause 26. So he's saying clause 24, you can't apply that because clause 26 applies here. And that was a complete, as we'll see in other references, both the Inner House and the House of Lords saw clause 26 as a complete code to deal with the circumstances that actually pertained, where Brown was removed prior to contractual completion date, Henshaw did the work, and Banstock recovered effectively the works to complete. But what Banstock also claimed was liquidated damages under clause 24, and that's why they're dealing with this point. So he says it contains a complete code in itself. And secondly, this is the second reason why clause 24 doesn't apply. On its construction, I read it as meaning that if the contractors had actually completed the works but had been late in completing the works, then in that case only the clause applies. And that was taken by the Court of Appeal to mean that the House of Lords determined, the Lord Chancellor was saying, that you have actually to complete the works before any entitlement arises or the entitlement is otherwise extinguished. And we suggest that's not the correct way to read what the Lord Chancellor says, and it's not what the other Lord said, and it's not what the Inner House said. The correct way to read what the Lord Chancellor was referring to is by continuing to read the next part of the paragraph. He identifies the clause applies under the circumstances in which this appeal comes before us. The contractors have not completed the works. On the contrary, they've been ousted from the works by the employer under the powers given them by clause 26, and therefore the same opinion as the learned judges in the Court of Session, who are unanimous in holding that clause 24 has no application to the present case. And the purport of that, we say, is also further explained by what Lord Shaw of Dunfermline said further down the page. He introduced the point in the first paragraph of his speech. He identifies the facts. Liquidated damages claimed against Brown, the original contractor, during the period stipulating the contract for the completion of the works, that is before contractual completion date. Another contractor, Henshaw, was called in. Damages, therefore, here claimed are claimed as liquidated in respect of such number of weeks as is estimated to be the time which Brown would have taken to complete the contract had Henshaw not been called in. This problematical estimate seems to me in its nature inconsistent with in principle with the very idea of paction or contractual damages. Clause 24 gives no foundation for such a hypothetical claim. What he was saying there is that the measurement that was, or the calculation of LD liquidated damages in that case that was being adopted was one which didn't look to the completion under the original contract. It tried to use the completion date under a separate and different contract. And he was saying, this is a contractual remedy. You can't calculate a contractual remedy to liquidated damages, which is linked to completion under one contract with completion of works under a different contract by a different contractor. What they weren't dealing with, though,
please complete the point because it's very important. And then I just want to ask a question.
Thank you. What they weren't dealing with, though, was the scenario which the Court of Appeal was dealing in this case, which is where termination occurs after the contractual completion date, but before the physical completion of the works. Thank you.
I just wanted to ask a question whether another way of looking at it was that clause 24 involved mutuality of obligation, namely that the employer should make it possible for the contractor to bring his liability for liquidated damages to an end. Otherwise, it's indefinite and infinite. That was the concern of the Lord Chancellor.
Yes, in a sense. Maybe I would express it slightly differently in the sense that the liquidated damages are obviously being a contractual remedy. One has to look at what the contract says about the relevant obligation, what you're getting damages for, what the breach is. And liquidated damages, I think as Lord Justice Scrutton identified in witness boundary, are an obligation to pay for a breach as defined, in this case, like Glansoff, failure to deliver on time, and you calculate them by reference to what the contract says you calculate them by reference to. And in a circumstances in which the contract says we calculate up to completion, that must mean completion within the terms of the contract you're talking about. So not a different contract. And the reason why it's important, it seems to me, is because if you stop the contract before completion and go somewhere else, there's nothing stopping an employer changing the essential nature of the works. You can change the definition of the quality of the works, the content of the works, the time for which they're to be completed.
I understand that. It seemed to me that it was an implicit and implied concern of the House that liability could be indefinite and uncontrolled, and that it could be varied by the alternative contract which you've postulated. And if it did any of those things, if it was so construed, it would, I think, be a real penalty, as opposed to an agreed liquidated damages clause. And that one should interpret it as having the effect of being a genuine pre-estimate of damage, or whatever the current test is.
Yes, and you achieve that, I think, by back to conversation I think I was having with Lord Leggett, discussion with Lord Leggett earlier on, which is Lord Burrows rather, which was the effective combination of that construction with the in the circumstance we're dealing with, which is where there's a termination before or discharge before completion, that necessary break, if you like, is provided by English law principles. The termination brings that obligation to an end for you. As I said, I think in response to Lord Burrows' question, you don't need to state that. That is what the law does. In Glansoff, as I think I've said, the liquidated damages clause had no application because the right hadn't accrued. So the liquidated damages were not accruing by the time that Brown was ousted. This was the point that Lord Shaw dealt with, effectively in the paragraph that I took your lordships to just now. The point that Lord Shaw was making, that the remedy applies only to failure to complete timorously, and the irrelevant epithet there, I suggest, for the reasons that Lady Arden has identified, is timorously under this contract. You can't apply that epithet to works done by somebody else on a different contract. It just doesn't. It's not relevant. The Glansoff clause is set out in my learned friends written case, but we can see it as we're in this area of the bundle in the decision of the Inner House, starting on page 810 of the bundle. It's in the footnote to the Inner House decision. It starts at the bottom of the last line of the page and goes over. Contractor failed to complete the works by the date named in clause 23 or an extended time allowed. Architect and the architect shall certify in writing the works could reasonably be completed by the said date or with an extended time. The contractor shall pay or allow his employer figures for all subsequent weeks as liquidated damages for every week beyond the said date or extended time as the case may be, during which the work shall remain unfinished, except as provided by clause 23. The clause didn't say that any accrued entitlement would be reversed or extinguished, and the clause didn't say that there'd be no accrual of liquidated damages until completion was achieved by the original contractor, by Brown. The clause did say, in my submission, exactly as Article 5.3 says in its own words in this case, that what you're looking at is a period defined by a start date, that is the date certified by the architect as being the completion date or the extended completion date, and the date by which he or she thought it should be complete, the work could be completed. For all that period of time, the works remained unfinished. And contrary to what the Court of Appeal said, we say with respect, the focus of this clause is on the lack of completion of the works. The works being talked about is unfinished. What you're looking for is unfinished works, not finished works. But it's essentially inconsistent to construe this clause as the Court of Appeal did in its interpretation of this, effectively this decision. But this clause was one which focused upon completion, which is effectively what the Court of Appeal said when it rounded off its assessment in paragraph 112 of its judgment on page 156. Where Sir Rupert Jackson said this clause, like clause 24 in Glanstoff, seems to be focused specifically on delay between contractual completion date and the date when Triple Point actually achieves completion. But that's essentially what was being implied there, is that you're looking for the actual completion and nothing before that, and no time before that. That's not what clause 24 was saying. In that respect, we suggest, respectfully, the House of Lords.
Mr. Howells.
Sorry, Mr. Howells. Again, just trying to get clear in my mind your precise submission. As I understand it, you're really saying that Glanstoff is plainly distinguishable from our case, because in Glanstoff, the liquidated damages that was being claimed was in respect of late completion by a substitute contractor, that delay, and therefore it's got no bearing on the facts of our case. Is that correct?
Absolutely. And that's the point we're making a written submission at the end.
Yeah. That's absolutely clear, is it? What I suppose I'm asking is, there was nothing in Glanstoff about any delay by Brown, was there? There was no issue about Brown being delayed, potentially therefore on your submission having accrued right, or the other party having accrued right to liquidated damages for the delay by Brown. We're entirely talking, are we, about delay ultimately by the substitute contractor?
My Lord, yes, but one gets that from the facts I set out in the inner house, I think page 810, 811. In fact, the contractual completion date in the Brown contract, first contract, was January 1910. Brown became bankrupt and was replaced some 3 or 4 months before that.
So there was delay by Brown in the sense of lack of completion by the contractual completion date, because bankruptcy intervened. But the complaint was made in respect of the completion date on the substitute contract. And that was the essence of, you would say, of the Glanstoff decision, that you cannot look to the substitute contract date.
Yes, although I think I seek to just clarify the first point your Lordship made, which is they weren't in delay in the sense that by the time their employment was terminated through bankruptcy and clause 26 was put into operation, they were not in delay.
So they were not in delay. They just ceased to be able to complete by the date in question, but they hadn't exceeded their contractual completion date.
No. Yeah. So clause 26 was then operated.
Yeah.
And that's the essential point we say. That's what one takes from Glanstoff, is that when you have that sort of clause, which is the point about the complete code in the Lord Chancellor's speech, and you see the equivalents in the inner house speeches as well.
Thank you.
I was going to take your Lordships to the inner house decisions, but I think I might just skip forward a little bit on that, because essentially what Lord Chancellor said, he agreed with all what they said. If your Lordship take time to read the decisions of the Lord President, Lord Johnson, Lord Mackenzie, which you'll find in the section I was looking at, which starts at 810, I would suggest that what you'll see is reasoning pretty much in exactly the same form, obviously expressed differently by each of the judges. What I would like to take forward, though, is a point which you've had in our written case, but I think what I'd suggest is relevant, is that the interpretation the Court of Appeal is given to the Glanstoff decision is one which one of the judges in the inner house himself, Lord Mackenzie was presented with in the case Cameron Head and Cameron about 7 years after the Inner House dealt with Glanstoff. In that case, if I could take your lordships to that, which starts at page 824 in the bundle. This case was a pseudo-construction case. It was to do with felling of trees on an estate in Scotland and a failure then to remove the trees. And it was the time for removal of trees, which was the relevant, if you like, period of delay that was being looked at. And the submission was made to the Inner House, including Lord Mackenzie, on the reclaiming motion in the Inner House, and we'll see this at page 828, that because the tree feller hadn't finished removing the trees and therefore hadn't completed the works, the action was premature. So the landowner couldn't sue because the works weren't complete, and the liquidated damages the argument was, don't accrue until completion. And that's the point made in the argument for the reclaimers, and by reference to Glanstoff in both the Inner House and the House of Lords by footnote 1. Lord Mackenzie then looked at that and dealt with that on page 831. At the bottom of the page, last paragraph of his judgment, where he says a great deal was made of a case decided in this division, British Glanstoff Manufacturing, referring to both the Inner House and the House of Lords in footnote 2 there. It was maintained that no action would lie on a clause such clause as this, unless and until the contract had been completed. The contract there was, the Glanstoff contract was of a complicated character. The judgment turned upon the point that there were two options given to the owner. One was to take the matter out of the hands of the contractor. The other was to allow the contract to go on and then enforce his right under the contract. He chose the former of the two. It was pointed out that having elected to abide by one group of provisions of that contract, he could not resort at the same time to another. And that's the clause 26-24 point that we were looking at. They used clause 26, couldn't also claim liquidated damages under clause 24. Over the page, 832, Lord Mackenzie says of the reliance on Glanstoff to argue that the liquidated damages don't accrue until completion. Accordingly, I think that case affords no support to the argument advanced by the defenders in the present case. Weir suggests that it clearly doesn't bind you, but the fact that Lord Mackenzie, who was one of the judges in the Inner House in Glanstoff, was asked to look again at Glanstoff and explain that in a way which is directly relevant to the point the Court of Appeal we're dealing with here, should be of some persuasive value to you. He was saying that wasn't what he was deciding, or what the Inner House were deciding in Glanstoff. And we respectfully suggest that's how the lordships should interpret the Glanstoff decision as well, such that it doesn't actually support the idea of a Category 1 group of cases. Now, the other point on the Glanstoff clause, which we say again is relevant, and it's relevant to construction of liquidated damages clauses generally, to the extent one is looking to categorise clauses in the way the Court of Appeal did. Also, here effectively for the reasons that I think were identified by Lord Leggett in his question about whether or not it would be open to PTT to claim damage at any point in time or wait for an invoice, is the reference in clause 24 of Glanstoff the best place to look at this, which we'll see, I'm afraid, back at the footnote to the Inner House decision on page 811. It's the last few words of clause 24 in Glanstoff. After having set out the obligation to the liability, it says in the last line, and such damages may be deducted by the employer from any monies due to the contractor, which we say was an indication in that case that there was an immediate right to deduct at any point in time, clearly inconsistent with the idea that one would have to wait until there was completion before one could recover liquidated damages. And this throws this throws a light, we say, upon the difficulties the Court of Appeal's analysis of Glanstoff and other cases like it, and Category 1 cases, will cause, if they are, if Category 1 is maintained. Because in contracts like this, which is a contract which my lay friends also identify as probably one of the precursors to the JCT forms, but is a clause which is very similar in its form to modern JCT in this respect, and the ICE and various other widely used standard forms. The clause gives the right to the employer to deduct liquidated damages from interim payments. Now, the Court of Appeal is right that there's a category of cases where liquidated damages clauses do not give rise to an accrual of the liquidated damages until completion, then those words are effectively rendered nugatory, because we wouldn't have a right to deduct anything at all until completion. But if the answer is, which is one of the alternatives, which is the alternative postulated by the Court of Appeal, that the clause upon early termination ceases to apply, which seems to imply the potential for an otherwise accrued right to be extinguished upon early termination, that gives rise to some real difficulties, we say. Because if there has been an accrued right to liquidated damages, as clauses like this would tend to indicate, having given the right to deduct LDs on an ongoing basis from interim payments, what happens when, legally, how would one analyse a scenario where early discharge through repudiatory breach or insolvency or any one of a number of the things that in modern contracting gives rise to termination or right to terminate, be it for fault or automatically, what do you do with those liquidated damages that have been deducted or taken away from interim payments? Because they would have been taken correctly under the obligations and of the parties at the time they were taken. There can be no suggestion they were taken by mistake, because unless and until the termination, the right to deduct liquidated damages will exist. But on termination, the extinction idea, the extinguishment idea, produces the result that on and because of termination, a previously accrued right disappears, change the nature of the obligation. And we suggest that's just not right. It's sort of English law, and your lordships shouldn't confirm a principle that gives rise to a scenario in which otherwise previously accrued rights are extinguished on and because of termination. If they're not extinguished because of and on termination, in the scenario I was postulating, where you've got liquidated damages deducted through interim payment, where is the provision that leads the contractor to recover, or allows the contractor to recover? It's not a mistake scenario. Some provide for liquidated damages to be paid back. But if the answer is suddenly you've gone from a situation in which you had an entitlement to damages for a period of time up until whenever it was all the period of accruing, and now you've lost that entitlement, you've got to work out how that gets paid back. And we say that also points to the fact that the appropriate approach and calculation should be accrual from stated due date or completion date up until completion, or if the contract ends earlier, on English law principles, you stop the accrual of liquidated damages and you shift to secondary obligations as defined by Lord Diplock in photo production. You claim your general damages therefrom. And we suggest the correct characterisation of the Glanstoff decision and the principles being discussed there is that of Justice Judith Prakash in the LW Infrastructure and Lim Chan San case in Singapore, which your lordships will see from starting on page 1005. And I would direct your lordships and commend to your lordships the reasoning of the judge in that case, as she reviewed and considered Glanstoff from paragraphs 13 onwards on page 1012. She reviews, this is an arbitration claim, so she's reviewing how the arbitrator dealt with positions. She describes the Glansoft decision, and then concludes on the first part, which is dealing with the arbitrator's conclusions that, like for appeal, that no entitlement arose. She says on page 1013, halfway down the page, under the discussion she had of Lord Mackenzie's decision in Glansoft in the House, the decision was about a different iteration of the well-established principle that no liquidators accrue once a contract is being terminated. In the absence of contractual provision to the contrary, which is the clear words point, LW submits House of Lords didn't intend that termination on the fact that the control of the contract had passed out of the hands of the contractor should constitute a new defence, that is, ending the right to LDs. I agree. And then she talks about that proposition as being the well-established principle of termination not affecting rights. That's the accrued rights point. Over the page, having discussed Bank of Boston, having looked at one of the leading books on construction, Hudson, she then concludes the present case has no express provision that stipulates the right to liquidate damages for the period agreed will be extinguished. It deals with 2 points and says that there's nothing here on the clear words, or on the words of the contract, which produce non-accrual or extinction of rights, and does that by reference to Glansoft. And we suggest that's the correct approach. The Court of Appeal suggested that Justice Prakash's review of Glansoft was possibly wrong because she hadn't had sight of the fuller judgments of the House of Lords. With respect to the Court of Appeal, the appellant suggests that's a little unfair on Justice Prakash. She clearly reviewed the in-house decisions. The in-house, we suggest, is no different in this respect to the reasoning of the House of Lords, with which the House of Lords confirmed its agreement. You have our written submissions on the decisions in Chantal and Gibson Thompson. All I'd say, in addition to those, if I may, is that in respect of Gibson Thompson, which your lordships have at page, the relevant part is at page 872, where the learned recorder deals with the question of claims for delay and inconvenience. This was a case, as we've identified, where there was no claim to liquidated damages. These are obiter remarks by a recorder discussing the party's decision not to claim liquidated damages in circumstances where the delay that was under discussion, if one likes, or in the subject of the claim, was delay after the repudiation of the contract. So what he's saying is, I agree with you. I think you couldn't claim liquidated damages in respect to the period after repudiation on normal principles. And what he's saying is, clause 2.3, which is the damages clause in under the heading delay and inconvenience, has it in the application logically. No party seeks to rely upon it. They're correct. I don't think it can be in the intention of parties that the liquidated damages clause, clause 2.3, should apply when the contract's been repudiated. As I mentioned above, the clause envisaged the works will be completed by the contractor and not by some other builder. And in my respectful submission, all that's happening there is the recorder was reflecting what is effectively treated as being the orthodoxy, which is you can't claim liquidated damages for a period after termination. And confirming, when referring to Glansoft, that's what he thinks Glansoft meant, not that you have physically to achieve completion of the works before any entitlement to liquidated damages arises, or if it turns out you fail to complete and you're terminated beforehand, that those rights are extinguished going forwards. The last point on this then is that the approach taken by the Court of Appeal, we say, in suggesting that all cases in category 2 were decided without reference to Glansoft, carries with the heavy implication that those were per incuriam and possibly wrong. And we suggest that's an unhelpful result to achieve, because as for the reasons I've given, we suggest that actually the Category 2 cases are the correct approach to take, which is that the damages accrue from the due date onwards. Secondly, if your lordships were to consider there should be a Category 1 in the same way as described by the Court of Appeal, then the appellant respectfully suggests that there would need to be some clear definition of what are the necessary indicators in a clause which will give rise to that result. This, in a sense, is an extension of Lord Barrow's point to me earlier on, which is should we now be saying to drafters of contractual clauses like this, you need to state in terms that there'll be a certain outcome if the contract is terminated early? Which the answer I gave was no, because law deals with that. The law deals with that. But if the answer is there is a principle of construction like that the Court of Appeal espoused in Category 1, then there's going to have to there will need to be some clear definition of which sorts of words or which words will give rise to that effect and which words don't. So the drafters can consider whether they are trying to achieve that result or not, and parties who have ongoing contracts can understand whether they are in a situation where, with what will inevitably be terminations coming in the current economic climate, they are looking at a scenario where what they thought they had in the context of a sound liquidated damages clause that was operating for delay will effectively be taken away from underneath them in circumstances where there's termination, or if they are safe, they can claim liquidated damages. I'm afraid the last 2 points are a little bit taken into account because I'm concerned about time, but those are essentially the points I have to make, and I rely upon those and the points in my written case in terms of those areas where I've analysed in greater detail, I would hope, the other cases in Category 1 and identified the potential negative outcomes, if I may put it that way, of adopting a Category 1 type approach, generally, or to this contract. So if I may then move on to the second. Thank you. So the second ground appeal relates to Article 12, and in particular, the third paragraph of 12, Article 12.3. Your lordships will be aware that there are two aspects to this. And the first, we say, is the exception to the liability cap resulting from the last sentence. And so if we may just look at Article 12, we're going to stick with this for a while because we need to look at the clause for both the remaining grounds of appeal. The relevant part at this stage, though, is on page 745, and it's the last sentence. This limitation of liability shall not apply to contractor's liability resulting from fraud, negligence, gross negligence, or willful misconduct of contractor or any of its officers, employees, or agents. And it's agreed that that is an exception which applies to the entirety of the limitation which are being imposed by the first part of the clause. Imposed by the second sentence, which reads, the total liability of the contractor, the PTT under the contract shall be limited to the contract price received. I want to come back to those words in the last ground of appeal. The structure I propose for this part of my submissions is as follows. I want to review the relevant findings of the trial judge, consider the approach to construction the Court of Appeal took, and address the reasons why the word negligence should be construed here to mean breach of the contractual obligations to exercise skill and care, the concurrent duties of care, as found by the judge. We suggest that the judge's findings of negligence bear a brief review of their context, and they can be seen in summary form in the judgment of Mrs. Justice Jefford in the core documents. It's her judgment, paragraphs 125 to 127, which your lordships will find at page 196. This is the case put by PTT. Was that PTT's failure to carry out or manage business analysis, business blueprint, functional analysis, design phase, delayed the contract and there was negligent business analysis and blueprint functional design, and then listed out under 126 on a number of heads the allegations of negligence and breaches of the contractual obligation to exercise reasonable skill and care and performance under Article 12.1. PTT had alleged delay was caused by the failure to adequately carry out those services. They were advanced as both a breach of contract and a breach of duty of care in the amended defence and counterclaim. And for the note, your Lordship will find that at page 617, paragraphs 122 and following of the amended defence and counterclaim. Yet those allegations were encapsulated in an issue, and the judge decided this part of the case based upon the agreed issues of the parties. And so those allegations were encapsulated in issue 5B, which we'll look at briefly because that's the way the judge decided the case. Issue 5B is described at page 166 in paragraph 15C 5B of the judgment, which sets out PTT's case, says it's PTT's case, there was negligence causing delay. When the judge came to decide, actually, while we're here, if I may just quickly as well identify to your Lordship's issue 8, which is the termination issue, again dealt with by reference to allegations of negligence and breach of contract, breach of the duty of care imposed by Article 12.1. When the judge dealt with this, she dealt with this in paragraphs at length through paragraphs 130 to 198 of the judgment. But the relevant finding, for your Lordship's purposes, is on page 211 in the conclusions of this part of the judgment on Part C, which is the delay section, 195 to 197 on page 211. In particular, I draw your Lordship's attention to paragraphs 196. The major cause of delay was failure to address software integration. I found on TPT's part there's a lack of willingness to address that. I find that TPT were in breach of contract in the respects relied upon by PTT in issue 5B, which is the allegations of negligence causing delay. The judge found that therefore the cause of delay was negligence and failure to exercise reasonable skill and care under Article 12.1, and that cause, this is paragraph 198 on the next page, the failure of the project, which is her reference to the termination, which she deals with further paragraph 227 of her judgment on page 218, deals with termination notices, and then reference to Article 515.3.1, which is the article entitling PTT terminate for failure to exercise reasonable skill and care. She's enlightened my decisions on the issue as to breach as to TPT's failure to exercise the professional skill and care to be expected. Subject to considerations of TPT's case, it's self-evident that I'd find them entitled to terminate under 15.3.1. So having found negligence, breach of the concurrent duty of care, the judge decides that caused delay and that gave rise to the right to terminate. The judge dealt with this part of the case in terms of the exception to the damage, exception to the limitation on damages at paragraphs 251. Apologies. Starting with 255, but in particular at 258 onwards. She discusses this part of the case. She says, on the one hand, we say correctly, breach of Article 12.1, which imposes the obligation to exercise reasonable skill and care, would, in common legal language, be called negligence, being a failure to exercise such care and skill. But if the exception applies under 12.3 applies to such breaches, then the effect of the limitation is severely curtailed. And that was the concern that led the judge in the next few paragraphs to then consider whether or not she should construe negligence to mean something other than breach of the concurrent duty of care. And where she gets to, having discussed the parties' cases, is at 262. So this clause is not easy to construe. Applying principles of contractual construction I've referred to, or recited rather, parties can't intend to exclude from the limitation of liability the breach of principal obligation appearing. As TPT puts it, the exception for negligence must apply to something else, whether a breach of duty of care in tort, other than a concurrent duty, or its tie equivalent. And the point the judge was making there, of course, is that any breach of a duty which is not contractual in this case would, by its very nature, not be a breach of the English law of tort, because the contract was being performed in Thailand, India, Singapore, and Dubai. So the opportunities that in terms of the implementation phase, in terms of the maintenance phase, the phase that comes afterwards, the obligations to provide the software, maintain it, provide 24/7 support, provide maintenance upgrades and the like, that could be in principle anywhere in the world, because what was being offered was a 24/7 support system. And we have no evidence about where exactly TPT was providing that from. Court of Appeal's treatment of this part is dealt with at paragraphs 116 to 122, which your Lordship will find on 156 and 157. And the key part of paragraph, the key part of the reasoning is at paragraph 119. And the appellant would ask your Lordships to note that notwithstanding what the Court of Appeal says about the judge's interpretation being correct, what the Court of Appeal has done in 119 is to approach it slightly differently, we say. The Court of Appeal says, if one reads 119, he looks at negligence, Sir Rupert Jackson looks at the word, saying it must be in context. The words describe unusual extreme conduct, such that Triple Point should forfeit the protection of the cat, which I'll come back to. It's talking about breaches of contract, which are also freestanding torts or deliberate wrongdoing. In my view, negligence in this context means the freestanding tort of negligence. So what the Court of Appeal seems to postulate is a scenario where you have a breach of performance of a contractual obligation, which is breached, and at the same time is a breach of an obligation in tort in negligence. We said probably that can be wrong for two reasons. One, the performance obligations here, for reasons I gave, were not being performed in England and Wales, so it's the wrong start point to assume what the cards are talking about when they use the word negligence must be the general law of England and Wales of negligence. Secondly, we say it's actually really very difficult indeed to identify a scenario in which the performance of the scope of work, this being a contract for in the implementation period for business consultancy, design, development, assistance with training, all advice type activities, which would attract often on normal circumstances tortious obligations under Headley-Byrne principles, but in circumstances where Article 12.1 expressly agreed that all of those services, certainly those ones of the advice type, would be performed exercising reasonable skill and care, it is difficult, we say arguably impossible, to identify a scenario like that postulated by the Court of Appeal, where you have a performance obligation under the contract within scope, performed in breach of the obligation to exercise reasonable skill and care, but also one which is a separate tort of negligence. It doesn't, we suggest, there is no such beast. And there is no such beast because for the reasons given by Lord Gough in Henderson and Merritt, if you're dealing with a scenario where there is complete coexistence and coterminous, complete coexistence, and the contractual obligations to exercise reasonable skill and care are coterminous with any tortious obligation, then you have, as the House of Lords in Henderson and Merritt, the reasons given by Lord Gough in that case, the right to choose which remedy you choose, which bit of law you rely upon. Now, in that case, obviously, it was being dealt with in the context of limitation. But it's just as relevant, we say here. The parties went into this contract and they used the word negligence in the context of a contract where, both by the nature of the works and by the express agreement, those works were to be performed exercising reasonable skill and care. There is no good reason, we say, to seek to find an interpretation of the word, which the judge quite rightly identified as being a commonly understood legal word, have some different meaning.
Could it possibly be construed as applying to tort claims in negligence, whether concurrent or not? Because there's no Headley, Byrne and Heller is irrelevant here, isn't it? Because tort claims are not governed by English law. So if there were a tort claim for negligence, on one view, you could get the cap wouldn't apply. But for that, you would have had to show that you did have a tort claim, which you've not tried to do, as I understand it.
We didn't, because no, we didn't try and do that. And the in the sense that the answer I'm going to give is both the reason why we didn't, and also why we say what your lordships shouldn't construe this clause to mean that PT should be required to do so. It's back to the same point, which is for the reasons given by the Court of Appeal in Robinson, which is cited by Malone and friends. The obligations in tort are supplied by the general law rather than by the parties' agreements. We have here a situation where the parties agree, here are your obligations, you're obliged to exercise a good many of them using exercising reasonable skill and care. And if you breach that, you basically come into Article 12.3, which we're construing. But if you're looking for another obligation imposed upon triple point, upon the respondent here, there's not one imposed by the contract, which I think has to be what one postulates to find an extra contractual civil liability. One can't be talking about negligence because the performance wasn't taking place in England and Wales. The performance taking place in Thailand. Now,
that prevent claim in negligence.
We have Thailand's a civil law country, so it depends what one understands about the law of civil wrong in Thailand. It seems my suggestion is extraordinarily unlikely that in this scenario, particularly when this contract is the parties are agreeing, this is an English law contract to which they give jurisdiction to the English courts to deal with breaches of contract under Article 27. That they are at the same time, when using this word negligence in trying to define the scope of their the exemption clause, would at the same time be suggesting that, notwithstanding the jurisdiction clause, the English court should be now investigating questions of civil wrongs committed in Thailand or Dubai or India or Singapore, simply to understand whether or not the word negligence, which has a perfectly obvious meaning, we say, in the context in which it's used in this contract, should be something else. Sorry, your sales.
Yes, thank you. I mean, just on that though, I mean, the clause uses terms which don't map directly onto English law concepts. So gross negligence is not a category of general law in England, although one can give meaning to it. So why shouldn't one apply the same approach to the word negligence and look to see whether that is a term which can map on to breach of a tortious duty, which one derives from foreign law, Thai law or Singaporean law, or wherever is the relevant place that one seeks to identify a tort?
Well, I'm just not seeking to avoid the answer. I just happen to notice the time. Now, my Lord Hodge said I should find a time. I'd like to answer the question. Should I do that now and then we stop, or?
Well, if you're happy to answer the question before the break, then please do so.
The answer then I would suggest is to be found in the way the contract structure works. The Court of Appeal identified, and there's no hiding this. This is something of a messy contract. It's pulled together from all sorts of other contractual documents, both those which were specifically negotiated with the parties, the terms of reference, clarifications, and the like. One of the documents that is pulled into this contract is the respondent's own license agreement. And the Court of Appeal referred to this, and your Lordship will find this starting at pages 788 of the bundle. It was exhibited as Exhibit 3 to the CTRM contract, that is at the lowest point in the order of precedence, so it's overridden by anything else. But the relevant clause for these purposes, I would suggest, is clause 7.4, which is one referred to by the Court of Appeal. You'll find that on page 790, in the first column of text after the box, about 2/3 of the way down. And you'll see a limitation clause there, which uses the words fraud, gross negligence, and willful misconduct, by omitting negligence. And the Court of Appeal said, well, there's consistency here between the two clauses, and we say, well, there's not, because the parties clearly inserted negligence into this contract. And we say that an appropriate way to deal with was effectively, in some respects, the history of the negotiation of this contract, to coin a phrase, baked into the contract itself, showing the parties having started the negotiation with just fraud, gross negligence, and willful misconduct, as proposed by Triple Point, and agreeing in the context of having agreed Article 12.1, which imposes obligations of reasonable skill and care, to expand that provision beyond gross negligence so as to include negligence itself. An appropriate way to interpret is the parties having gone through the process of deliberately extending the scope of the limitation clause that would otherwise have pertained if they'd stuck with the perpetual license agreement version, is that they would have done so in recognising the relationship between Article 12.1 and the obligations Article 12.1 impose, those concurrent duties of care, and the use of the word negligence. And not because if they were trying to do something different, they were trying to say, well, it's more than just negligence. It's more than just gross negligence here. But I don't mean negligence in the sense of we don't mean negligence in the sense of a breach of concurrent duty of care. And at the point at which they expanded the clause and put in the word negligence, one might expect them to say so.
But just on to pursue the point that I was putting to you, I mean, in some ways, one might think that if the origins of our clause 12.3 is this terminology and then an addition, and this terminology is not seeking to map onto English law legal concepts. I haven't been able to find what law governs this, but I assume that it's some American jurisdiction. But anyway, the language clearly here isn't intending to invoke English legal concepts. And if the parties add in a new concept to the list, why isn't the inference that they don't intend that to map directly onto English law concepts, but just to provide a contractual template? And if there is tortious liability that arises under any legal system, one applies the contractual language to see whether one can describe that fairly as negligence, in which case you're outside the provision.
In response to that, I think my response to that would be, if within what your Lordship is saying about mapping onto English legal concepts, finding separate legal liabilities under the heading gross negligence, willful misconduct, because fraud obviously is, then I would disagree. That's what's going on here. These are descriptors that English lawyers recognise. They describe aspects of behaviour which are, by the nature of this clause, because this clause is only about breach of contract. The clause starts by saying the liabilities of breach of contract. They're trying to describe aspects of behaviour which an English lawyer would recognise as being qualitative descriptions of breach. If you're doing that, why would you look to map it onto a different and non-contractual obligation or liability? Because the clause doesn't deal with those. The clause isn't trying to limit liability for a non-contractual civil wrong. It's trying to limit liability for breaches of contract.
Yes, thank you very much.
If that's
a convenient place, Mr. House, we will adjourn for 5 minutes. Thank you very much.
Thank you.
Mr. Howells, resuming after the adjournment, can I pick you up on your last point? You described the expressions used at the end of clause 12.3 in the fourth sentence as qualitative descriptors of the breach of contract. So do I understand your submission to be that clause 12.3 creates a contractual liability, it then caps that liability, and the fourth sentence, where it refers to this limitation of liability, is referring back to the contractual liability and is saying that that contractual liability, which has the following descriptors, is not subject to the cap. Is
that's my submission.
And it is not, you say, simply a confirmation that this is only a contractual liability cap and not a tortious liability cap.
Yes, effectively. One gets that from the first sentence of 12.3 on page 745. The contract expressly states what the liability is. Contractor shall be liable to PTT for any damage suffered by PTT as a consequence of contractor's breach of contract.
Yes.
Yes. And then you roll forward through. So that was the basis in which I was responding to Lord Sale's questions on in that respect.
That's what I understood you to be saying, but I just wish to confirm that. Thank you.
So without wishing to round that point off, and hopefully not labouring it too much, the point about which you'll have had from our written case, which in a sense the Court of Appeal recognised by stating this has the position they were postulating had to be both a breach of contract and a tort. We say is a different one to understand in this context, given what this contract was and what the parties should be taken to have conceived of the contract at the time of contract, which is obviously the test one needs to be applying when construing the words. The example the Court of Appeal sought to give, I don't want to labour this too much, which is of the electricians wiring up and negligently wiring, was wrong for the reasons we've given in our written case. This is not an M&E contract. This is a software design and development contract and its implementation. There is no physical wiring done. This is not a hardware infrastructure contract. It's all that software. So the example doesn't pertain. We say that being example taken as being or used to illustrate the point is wrong. It indicates that the Court of Appeal hadn't understood the contract in that respect. But also, even if it were a relevant example, it would still be one which supports what the appellant says about this clause. We say, if the services included the undertaking of wiring works to wire up servers or whatever else happened to be in a data centre, say, then under 12.1, the parties would have agreed that those services, including the wiring works, would have been undertaken exercising reasonable skill and care. So we're still in the same problem, in a sense, which is that the contractual obligation would be to do it carefully, and the word negligence was still applied just as much to what is basically a concurrent duty of care to wire carefully, as much as it is to undertake consultancy carefully.
Could you just give us an example of a breach of contract that would be covered by the cap? Just to understand your submission that you make in your case, that it does have some effect, this cap.
Absolutely, which is essentially the response to the Court of Appeal's point about depriving the limitation of any effect. And we say it's the wrong test, actually, because photo production says that that's not the test you apply. You don't take a view on the wisdom of the parties' deal. But actually, there are plenty of examples. We've listed out the clauses And I was going to give you, I was going to give you two, but for time purposes, just one example, and that is the example of Article 6, the confidentiality clause, which your lordships will find in the bundle, starting page 741. And this runs over 5 numbered subparagraphs plus 2 paragraphs at the end. It defines confidential material in 6.1. Undertakings are given to preserve and use in 6.2. 6.4, obligations as to how to deal with confidential material, seek consent and the like. None of these are obligations which are on their terms to be fulfilled only using reasonable skill and care. They're absolute obligations by the nature, but one by what's said in the contract, two by the nature of this sort of term. So this is an obligation. If confidentiality were breached under Article 6, it will be a breach, not necessarily of exercise, not necessarily a negligent breach. It will be a breach in absolute terms. That breach would be caught by the limitation on liability under Article 12.3. But if the breach were the result of negligence or fraud or willful misconduct or gross negligence, then the exception to the limitation in the fourth sentence would apply. So unlike what the respondent says of this contract, which is that Article 12.1 essentially elevates every single obligation into an obligation to exercise reasonable skill and care, that's not correct, we say.
But confidentiality is a bit of a side issue. Is there anything connected with the work that's an absolute obligation, or is it all only an obligation to take care?
In terms of providing,
are there any warranties of quality or performance or anything like that?
And all the warranties of quality are in the in respect to the software are contained in the perpetual license agreement, 790, and those warranties apply primarily, in fact, to the post-implementation period, because that's when the software is live and running. Clearly, they'll have some application implementation period if they cause delay. Effectively, one could be delayed by a piece of inadequate software failing its testing repeatedly, for example, pre-implementation, pre-go live. But there certainly all those obligations exist. And as we say in a written case, this contract is not just about implementation. There are two distinct aspects of this contract. The implementation phase, which is what we've all been focusing upon, goes up to go live. And that is a phase which is in very large measure the provision of services which are of the type which required reasonable skill and care to be exercised. And that's what 12.1 said. The services set out in the terms of reference, which are consulting on the business, designing the software, developing the software, training users, testing, are all ones to exercise reasonable skill and care by their nature and by express agreement. But there are the quality obligations in that sense that go to the substance. They're also in the substance of the obligations in the what I call the operational period, that is after go live during the maintenance period, the following 3 to 5 years, extending into the future indefinitely for as long as PTT paid the maintenance fees. Those ongoing warranties as to quality of software not just the base software, but all of the upgrades and the fixes and the bug fixes, the obligations to timings by which bugs will be addressed by the support desk. But back to your lordship's point, which is, does one have to find a substantive obligation in the implementation period, which is not one to be exercised, to be performed, exercising reasonable skill and care? The answer, I would say, is no, because this contract is, when some commentators talk about contracts being a net, in that sense, they mean the net is defined as much by the strings as by the gaps. The strings of this net are defined, obviously, primarily in the implementation period by the obligation to perform the business consultancy and design, develop, test, train, and go live. But around that are also the obligations to make sure that Triple Point doesn't breach confidentiality, that Triple Point only uses subcontractors that are agreed. All of those obligations are there. They're as much part of this agreement as any other obligation. And those are ones which don't come with the agreement to exercise reasonable skill and care. They are obligations which in certain circumstances could be breached by a failure to exercise reasonable skill and care, or grossly negligently, or by willful misconduct, or by fraud. So it's not right to suggest that this contract can only be breached by a failure to exercise reasonable skill and care, so that the effect of the fourth sentence removes any right at all. I'm very aware of time. I wonder if I can beg to borrow about 10 minutes from my response to just finish off on the third ground of appeal.
Yes, you can do so.
Thank you. The last ground, if I may just move on. Again, like I said last time around, I haven't managed to cover every part of what we've said in writing. We rely upon that as well, but those are the reasons in principle why we say the fourth sentence should be interpreted as the appellant says and not as the respondent says, as the Court of Appeal said. Last point then, this deals with Article 12.3 again. It's once again an aspect of the construction of the limitation clause. This bit relates to the relationship between the second sentence and the third sentence of Article 12.3. The second sentence you'll see starts just before the underline on page 745. The total liability shall be limited to the contract price received with respect to the services or deliverables involved. And then, except for the specific remedies expressly identified as such, PTT's exclusive remedy, the written contract will be contractor upon notice, written notice to use best endeavour to cure at expense, or failing that to return the fees paid for the services or deliverables related to the breach. A number of points. First, contrary to what the appeal said and what the respondents say, the second sentence we suggest is not a total cap in the sense of an overall cap on liability, defining, if you like, an agglomerated cap. The reference in those words is to the liability being limited to the amount of money paid with respect to the services and deliverables involved in respect to the breach. So what one does in the second sentence is identify whichever service or deliverable, this is in the implementation period, similarly in the operational period, has been breached, and you look for a value, the contract price paid. In the third sentence, just to deal with this point before I go on to what that value would be, you have, once again, once you get past the exception and past the cure remedy, a statement which is that the remedy is to recover the price paid for the services or deliverables related to the breach. Now, the words are slightly different, but we say the words have exactly the same meaning. Again, you are being directed to look for the value paid in respect of the service or deliverable in respect to which there's been a breach. The two are actually the same. They're the same in that sense, in pure linguistic terms. They're the same, and parties agree this, we suggest, in their actual operation, in the sense that, contrary to the proposition in the Court of Appeals judgment, that what you're looking at here is the difference between an agglomerated cap or an overall aggregated cap in the second sentence and a series of mini caps in the third sentence. Both parties come to your lordships on the basis that we recognise, that the respondents recognise, as we say, that it is not possible to identify or value mini caps in respect to individual breaches. The third sentence, which refers to identifying the amount paid related to the service or deliverable, must mean, by reference to the lump sum percentage milestone payment that is being made. Because the services and deliverables, which are set out at some length in a long list in part of the contract with the terms of reference, starting at page 780, over some 5 pages, sorry, 6 pages, describe an undifferentiated basis numerous documentary deliverables, various plans, business consultancy documents and the like, as well as activities and services which go into the production of those deliverables. And that's what's being referred to here. So when you try and identify what is the contract price paid for a particular service, say there's negligence in preparing the as-is business consultancy document in respect of one particular part of the business system, you can't identify what contract price paid for that is, because the parties agreed the contract price was being paid by reference to percentage lump sums, which were percentages of the total contract price, undifferentiated. And the court recognised this when they said, well, the minicaps, it gives right when they said in paragraph 126 at page 158, there'll be some difficulties here. That alludes to the point that's being made to them, which is there is no contract price referable to a service or to a deliverable. You must mean the milestone caps, or the parties must be taken to mean the milestone caps. If they mean the milestone caps, then the limitation in sentence 2 is for that reason as well, just the same as the limitation in sentence 3, because the contract price paid for a service deliverable in sentence 2 is the milestone, and the contract price paid and recoverable in sentence 3 is also the milestone. So that leads to a situation where we've got two sentences apparently looking at the same thing, but with different words. And we suggest that the trial judge's answer to that difficulty is the correct one. This is a difficult clause and recognised by the judge, by the Court of Appeal, and by the parties throughout. There is, we suggest, probably no way to interpret this clause without doing some damage to the word, because one can't make both parts of that clause work together without doing some damage to the words. So what the court must do is to identify the best result based upon the intention of the part, the objectively identified intention of the parties. And we commend the judge's conclusion, which is what you're seeing is the second sentence defines the limitation, and the third sentence that expands and explains how that's to operate, identifying that there are to be on notice an attempt at cure if possible, and if not, then you roll back to you come back to the overall limitation, which is you get the contract price. The words of exception, as the judge decided, we say, accept specific remedies from that process, and they do so in respect of both parts of the limitation. And this is certainly not suggesting this is at all easy. That must be the correct conclusion, we say. If it isn't what happens, it isn't the way to construe a contract, you end up with some very difficult results. Because if the specific remedies are not excluded from the second sentence, so they are subject to the limitations set by identifying the master price in respect of a breach or in the production of service or deliverable, but they are excluded from the third sentence, then you have a situation where specific remedies are both excluded and not excluded in the same terms.
I don't see the problem with, sorry, Mr. Knowles, I don't see the problem with that, though, given that the third sentence has a requirement to endeavour to cure the breach at the contractor's expense. And so it's accepting from that a situation where you've got liquidated damages, for example. Still makes sense, doesn't it?
Well, you have to read the exception as being only related to the cure remedy.
Well, on your interpretation of the last part of that it doesn't add anything to the second sentence, because the fees are, you say, the milestone payment. But it still has significance for the endeavour to cure, which is an additional limitation from which specific remedies are accepted.
Yes, in a sense, I suppose. If one reads it narrowly like that, the result, though, will be, as we identified in our written case, that what the result one achieves, but whether one looks at liquidated damages or the remedy of indemnity, for example, in Article 13. If you limit those remedies to the amounts paid, one gets into this scenario we've identified, which is effectively incentivising non-performance, because the less good the performance, the lower the liability. Effectively, what you put in the contractor's hands, in Triple Point's hands, is the ability to have to exclude liability by not achieving the first milestone, for example. Because if all specific remedies, liquidated damages and indemnity, for example, are subject to this limitation, that is, your limitation is limited only to the amount paid. If you've paid nothing, Triple Point's liability is nothing.
Well, that can happen, but it's not totally unusual, is it, to have a recovery of price only liability if the contractor's driving that bargain?
No, I think it's more unusual in terms of delay cases, the delay remedies, and it certainly cuts across the concept and the existence of the indemnity clause in Article 13.
Thank you.
Well, I think I begged 10 minutes more. I've taken my 10 minutes, so I think I'll stop there.
So I think, in fact, you've taken 8 of your 10, but it matters not. Thank you very much. Mr. Stafford, your time will be extended to 2:30, and Mr. Darling's to 3:40.
Thank you very much. I'm not sure whether we will need all of that time, but you never know. I'm going to address 2 of the 3 grounds of appeal. That's to say whether or not the liquidated damages fall within the scope of the damages cap, and also whether the damages caused by Triple Point's breach of contract fall outside the scope of that damages cap. And Mr. Darling is going to address you on whether PTT's claim to liquidated damages under Article 5 accrued before the termination of the contract. And I hope that will make plain how our time is going to be spent. As I said, I'm going to start with whether the liquidated damages are inside the cap or outside the cap. Can I take you straight away, please, to page 745, which is Article 12.3. And as is known to you, this clause has been divided out into 4 separate sentences. I'm going to refer to them as sentences 1, 2, 3, and 4, just for convenience, and hope that that won't be inconvenient to you. The essence of Mr. Howell's case is that the exception that begins sentence 3 should be read as beginning sentence 2. We say that that is, on its face, not possible. If the parties had intended to have an exception to the total liability cap, they would have provided for one. And we also say that the exception to sentence 3 serves a useful purpose. It is fair to say that PTT is quite explicit in what it is asking you to do by way of interpretation. For your note, at page 65 of the bundle, at paragraph 125 of the written case, the appellants first describe the fact that these sentences are a bit tricky, but then effectively pin their colours to the mast. This sentence continues, the words of exception would be easier to interpret if they were placed at the beginning of sentence 2. So they're quite clear in what their objective is here. We say when one looks at sentence 3 properly and sentence 2 separately, one can see that they perform very distinct functions. Sentence 2 is providing an overall cap on liability for damages under the contract. It doesn't prescribe how one gets to that cap. It doesn't say it should be measured in one way or measured in another way. It is simply saying, by whatever route damages may have arisen, you will not get more than the figure, which is a moving target over the course of the contract, that has been paid to the contractor under the contract. As a standalone clause, it is entirely comprehensible. Essentially, it comes to a kind of money back compensation for the employer, which places the employer in the position, if it wishes, to start over. The third sentence performs a very different function. Its first function is to prescribe exclusive remedies. And as my Lord Legate has identified, the first of those is cure. The second is return of fees in respect of the services or deliverables related to the breach. And you'll observe that last phrase, related to the breach, is a phrase which is not to be found in sentence 2. This is focusing on individual specific breaches. So primary remedies, exclusive remedies of cure, and repayment secondary. But that last phrase, return of fees paid to contractor for services or deliverables related to the breach, is describing, unlike sentence 2, the measure of the financial remedy in the event that a cure does not work. True, it isn't spelling it out in a particularly, there's not a particularly easy formula to say this is how many pounds and how many pence it will be. But in a way, this is just the flip side of extra works in a contract. What it is saying is that the damages will be measured as the value received by the defaulting contractor in respect of the defective work. And that is, if you like, the negative version of the entitlement of the contractor to the value of the extra works that the contractor has done beyond the scope of the contract. And the reason I mention this is that in many contracts where extra work is involved, the parties will prudently prescribe a means by which the value of the extra work will be identified. It might be an umpire, it might be a quantity surveyor, it might be a certifying architect. But those are simply means of tackling the problem of placing value on extra work. These parties have set a different valuation problem. What is the valuation of defective work? And they have chosen to make life hard for themselves by not including an umpire, a certifying engineer or architect, or quantity surveyor. But there is nothing in principle or as a matter of logic wrong in seeing that that is an entirely reasonable way for parties, if they choose, to describe how individual breaches of contract should have a financial remedy measured. But if it did not have, at the start of sentence 3, an exception for terms for which a specific remedy had been provided, then the exclusive remedy of cure and valuation would swallow up the liquidated damages clause, which appears at Article 5. And prudently, this makes exception for precisely that contingency. And so the exception that appears at the beginning of sentence 3 serves not simply an important, but a vital role in the context of individual breaches of contract by directing the reader to know that the liquidated damages clause is not subject to the primary remedy of cure, nor to the secondary remedy of valuation, but has its own remedy. So if one takes a step back and asks what it is that the appellant is seeking to do, he doesn't simply want to cut and paste the exception from sentence 3 and paste it into the beginning of sentence 2. He wants to copy and paste the exception that appears at the beginning of sentence 3 and add it in to sentence 2. And we say that is a wholly impermissible exercise. But the fact that he needs to do copy and paste demonstrates the independent value and function of sentence 3 and makes it obvious that we are correct in saying that sentence 2 performs a wholly different, wholly desirable purpose in the interests of the parties as they identified it, which was to place a cap on the total liability, not prescribing how one might measure that liability. And because it doesn't direct how one might measure the way in which the number is reached, whether it's by reference to milestone 1 or milestone 2, it is simply introducing a number which is the maximum number, whether it be achieved by way of a financial remedy under sentence 3 or a financial remedy under the liquidated damages clause. It says, this is it, money back, no more than money back. And we say on that basis, sentence 2 and sentence 3 are easily seen to have separate lives, separate meaning, separate function, and they are not to be squashed together in the way that Mr. Howells suggests that you should do. In our respectful submission, sentence 2 and sentence 3 were correctly construed by the Court of Appeal, and the consequence of that is that the liquidated damages fall within the scope of the total liability cap. Mr. Howells has made reference to the indemnity, saying how can you get the indemnity, which makes work in this context? Isn't that a special remedy? We have made our submissions in relation to that, and I can come back to that in greater detail. But the essence of our submission is this. Article 12 is directed to liability and responsibility on a party and party basis. You breach the contract, you have this remedy, we have that remedy. Article 13 is essentially covering third-party liability that may come to rest with one or other of the contracting parties. And one can see that that is the purpose of it from the nature of the words that are used. It makes perfect sense to say, you must hold me harmless from claims that third parties bring against me. It makes no sense to use language which says, you must hold me harmless from claims I bring against you. So the words themselves point in the direction of a third-party indemnity, not attributing risk on a party and party basis for breach of the primary obligations. Moreover, the breadth of the indemnity, as we spell out in our written case, is such that it makes all the debate, if it were correct as a party and party indemnity, makes all the debate about Article 13 entirely redundant. And that's because each party promises to indemnify the other party from all losses, damages, liabilities, and claims arising out of, and then we go a bit wider, or relating to, and then we go wider still, the performance of the contractor under this contract. Absolutely no need for any breach of contract, any negligence. All it is if I've suffered losses as a result of your performance of this contract, you must indemnify me. That's the consequence of construing it as a first-party indemnity. If it's construed as third-party indemnity, that problem doesn't arise. But one wonders if Article 13 has the breadth for which PTT contend, why they bothered suing for breach of contract at all. Why not just make the claim under the indemnity? Sidestep entirely the total liability, sidestep entirely the exception for specific remedies, sidestep entirely the return of fees as the secondary remedy. So we say, trying to equate the liquidated damages clause and Article 13 indemnity as specific remedies within the purview of sentence 3 is going down a rabbit hole. And it is an approach which, in our respectful submission, you should reject. My Lord, I'm so sorry, yes.
Lord Barrows.
Yes.
Can I just see if I can put in my own words what I think you're submitting about sentence 2 and sentence 3, or might it be seen in this way? That if you've got a situation where you're still looking forward to the contract being performed, then the exclusive remedy is that the contractor at its own expense shall use its best endeavours to complete. In relation to that, you would still have a claim for liquidated damages if that performance was late.
Yes.
But then if we're not in that situation and we're looking back, so to speak, cure is gone and so on, then sentence 2 just tells us overall what the looking back position is, that there's a total cap. Might that be one way of looking at it?
It might be one way. The return related to the return of fees paid,
Yeah.
in each of these presupposes that there has been a level of performance such that the PTT has felt able to accept the work, because payment is only made under Article 18 once PTT has accepted the work. Only then can Triple Point issue an invoice, and only then can the invoice obviously be paid. So the way we put it in our written case is that if you can see it on the ground before you've reached payment, then the exclusive remedy is put it right. If you can't see it on the ground at the time when you get to the milestone and you think it's right, and you accept the work and you pay for the work, but if it turns out not to be right, a latent defect bubbles up to the surface, then the exclusive remedy is the return of the fees that have been paid in relation to that. But because there are a whole host of obligations, performance obligations, very, very detailed, I'll come on to that in a second, under this contract, there could be all sorts of activities which might generate a need for a cure, alternatively, a need for the return of the relevant portion of the fees. The separate purpose served by sentence 2 is wherever your claims for damages may come from, whatever form they may take, liquidated damages or return of monies for individual breaches, it won't go above the total cap of the amount of money that's been paid. We get our money back in those, that's the maximum we can get. But at least then we'll be in a position, if we get all the money back, to start over. Now, the reason that I've said to you, there's all sorts of ways in which the contract, there could be contractual non-performance, is that amongst the contractual suite of documents was something called the technical clarifications. And these were essentially a dialogue between PTT and Triple Point in the run-up to the contract itself. And a question would be asked by PTT, and a response would be given by Triple Point. And if I could just show you what they look like, it may, I can, yes, if I could take you to page 786, which is part of the core bundle. And this is one part of the technical clarification. And each box contains a question and answer. And you'll see in the bottom left-hand corner of page 786 that this particular page is the 35th page of a 53-page document. That 53-page document is part of the contractual suite, which you can see, and just for your note, at page 754 of the bundle. Article 28 describes the documents of which the contract comprises, and Exhibit 2 is the technical document clarification. So there were myriad tasks that would be necessary each of which would count as a contractual matter. So having something which under sentence 2 demands put it right first, and then secondly, if necessary, return the money. It's a very, very meaningful clause. It's not merely, certainly not merely, but it's not at all replicating sentence 2. Sentence 3 is dealing with the fact that there is a lot of work that has contractual status confirmed by the technical clarifications document. And the consequence of that is to draw all of those into the exclusive remedy provision. But the work of that remedy has to exclude the liquidated damages clause. And in many ways, the liquidated damages clause is the easy route through, because if one thinks about it, if I'm breaking these promises one after the other, not performing well, and I'm being told to cure the defect, the attempt to cure the defect on numerous occasions is highly likely to generate a delay in overall performance, and highly likely, therefore, to trigger, on our case, a contingent, on PTT case, an accrued claim for liquidated damages. But one can see how the scope is there for an easy route to claim a known amount of money, because the delays which come about through a failure to cure, the delays that come about through non-performance, would give rise to this contingent claim to liquidated damages. And because of that, we say that PTT exaggerates the problems of valuation which they attach to sentence 3, talking about what are the fees paid for the services or deliverables. Well, it may be that the parties roll up their sleeves and decide they will have an argy-bargy about exactly how much of the fee paid related to a particular defect. But it may be that PTT says, blow this for a game of soldiers. You're 2 weeks late in doing this. I'm not going to spend more time arguing about the value of that. I'm just going to go straight to the liquidated damages clause. And I'm going to say, you are late. Here's a calculation method. I'm going to rely on that instead. And so one can see why it was so valuable to the parties, particularly valuable to PTT, to have a function served by the exception to sentence 3 in Article 2.3, which is entirely separate from the total liability, which is a money-back guarantee maximum. And that's part of their risk allocation, and it's a meaningful one. My Lord, unless I can assist you further on that point, I was going to move on to deal with the total liability clause itself. Happy to do so now. Happy to do so. If you want to break at this point, happy to resume 15 minutes early.
If you move on, I can see no one wanting to ask any further questions about that. Move on to the second one. Thank you very much.
Thank you very much indeed. Sir Rupert Jackson said it. The total liability clause means what it says. I've already demonstrated to you how we put our case, that it's not subject to the exception. I want now to tell you what we make of the limitation liability exception at the end of Article 12.4. Can I take you then back to page 745, which is where you'll see 12.3 and sentence 4. What you will observe is that in sentences 2 and sentence 3, the phrase under the contract, arising out of this contract, are present. So in sentence 2, the total liability of contractor to PTT under the contract shall be limited to the contract price with respect to the services deliverables involved under this contract. And then in sentence 3, leaving to one side the exception, PTT's exclusive remedy for any claim arising out of this contract. By contrast, when one looks at sentence 4, what is striking by its absence is any phrase or the equivalent of under the contract arising out of the contract. This limitation of liability shall not apply to contractor's liability. And this is where you expect to see the phrase under the contract arising out of the contract. But the draftsman has chosen to omit that important phrase. And what we draw from that is that the panorama of liability that the draftsman has in mind when drafting the exception to the total cap is a broader panorama than the contractual panorama. It's basically saying this is the boundary between the risk allocation that's been made by the total liability clause and the wild world out there where anything can happen and often does and gives rise to all manner of liabilities. We are not legislating for the wild world beyond this contract. And therefore, if something from there does crop up, which generates a claim for damages, don't think that you're going to get the benefit of our carefully crafted cap returning money for work done under the contract. That is the point of sentence 4. It's saying in terms, and when one looks, I beg your pardon, my lord.
I mean, on that interpretation, it is OTOs, isn't it? Because the cap doesn't apply to liability outside the contract anyway. So you have to say it's just rubbing it in, so to speak, but doesn't actually serve any necessary function.
With respect, I entirely agree. It's one of my notes was to say to you, it's for the avoidance of doubt clause. And we don't resile from that. We say that it serves a very useful purpose, although one may question how useful that is, given that we're now in front of the Supreme Court arguing about the function of this clause. But if one's looking for something that unifies the concepts within that sentence, I put it this way. This is answering the question: what about matters that are not within the ordinary course of contractual non-performance? These are all not in the ordinary course of contractual non-performance. Contractual non-performance has been legislated earlier in Article 12.3. This is just answering the question, what about the rest of the stuff? Out of the ordinary, not in the ordinary course of contractual non-performance. And so one can see by looking at this that each of those words, descriptors, to use Mr. Howell's expression, has meaning. Fraud, well, frankly, if there's fraud, of course, all bets are off. There's no reason at all why there should be a cap that would protect a fraudulent contractor. And bear in mind that the fraud could arise in the inception of the contract, or it could arise in the course of the contract. But whatever it is, it's certainly not in the ordinary course of contractual non-performance. Say, for example, hypothetically, suppose there had been a fraudulent misrepresentation at the inception of the contract that Triple Point owned the intellectual property rights to the software. Suppose in the course of performing the contract, it was fraudulently described to PTT that important work had been thoroughly checked when everyone knew it had just been lying on the in-tray gathering dust. Two ways in which one would perfectly properly say that wasn't what we were legislating for when we introduced the cap. What about gross negligence? Well, again, if challenged to come up with an example of that, where one might say give an example of out of the ordinary run of contractual non-performance. What about a Triple Point manager who delegates important work to a subordinate whom he knows to be drunk? In those circumstances, why should there be the benefit of the total liability cap if you're going to be effectively reckless in giving highly skilled work to somebody who is not able to perform that work for a reason you know? Again, why should you? And what about willful misconduct? Here's an example of that. Suppose somebody maliciously embeds a bug in the software or does something of that sort when embedding it. It's going beyond the scope of reasonable skill and care it's something entirely different. Again, no reason why the total liability cap should attach to that. So what then is the purpose? Having shown a purpose to all these other words, what is the purpose of the word negligence? It's clearly, in our respects, looking for something that is of a similar ilk. And the example that we would give, and it doesn't need to get tied up with English tort concepts or Thai civil law or anything of that sort. What sort of negligence might there be which could give rise to a legitimate complaint that this wasn't what we bargained for, you shouldn't have your cap? And the answer is people. It's the way in which people interact that gives rise to extra contractual assumptions of responsibility, which give rise to damages. And a really good example of that would be, suppose, whilst on site, a TPT, triple point engineer, is asked by a PTT guy, my desktop isn't working. You're the IT expert around here. Please, can you have a look at it and see if you can fix it? Absolutely outside the scope of the contract. And in those circumstances, the triple point guy says, yes, I'll do it. And he causes highly important, commercially valuable data to be irreparably damaged and lost forever. That might be the kind of assumption of responsibility outside the scope of the contract, which would be said to be negligent, would not, in our respectful submission, attract the benefit of the cap, because that wasn't what was bargained for. Outside the contract, outside the ordinary run of contractual performance, the cap doesn't benefit. And we say that the assumption of responsibility as giving meaning to the word negligence here, again, we don't have to get caught up in questions of proper law of the tort and so on. There are a couple of cases which are quite helpful to look at. It may be that should be where I should pick it up after the short adjournment, my lord. I was going to take you to authorities.
Well,
sorry.
Leggett has a question.
I'm sorry, Lord Leggett.
No, well, it's quite common, but very common, I think, to see as an exception to a limitation of liability clause or an exclusion of liability clause, gross negligence or willful misconduct, or sometimes it's slightly differently worded, willful default or something. In those circumstances, it's undoubtedly dealing with a breach of contract, but one which has a certain character, which makes it inappropriate for the limitation or exclusion clause to apply. I mean, the force of Mr. Howell's argument is that you would expect the other things that have been added to the clause to have the same character, namely that they qualify breaches of contract where there would ordinary, as well perhaps as, if you like, breach events outside it, but they qualify breaches of contract, and where it has the character of negligence, the limitation or exclusion isn't covered.
Yes, my lord. I think the difference between me and Mr. Howells is how we identify the genus to which we apply the justem generis rule. He applies it to breaches of contract, and I say not so fast. It is not trying to describe breaches of contract when it talks about negligence. And the genus is I forgot my own phrase here. It is events which go outside the ordinary course of contractual non-performance. That's
but my point is that gross negligence and willful misconduct only operate within the contractual context, don't they? You can't have a freestanding claim for gross negligence, at least not known to English lawyers.
Absolutely. That takes me back to my response, which is, what is the genus? Our genus is one that embraces both bad behaviour with regard to the subject matter of the contracts and bad behaviour by assumption of responsibility alongside the contract, but not part of it. And the reason that I say that is because of the consequence of adopting Mr. Howell's genus is to throw the baby out with the bathwater to all intents and purposes. That when you look at what is covered by negligence. It covers the whole world of reasonable skill and care. And the way in which Mrs. Justice Jefford dealt with this point in her judgment is very well put. It's in your bundle at page 223, at paragraph 262. And in that paragraph, if I may read it to you, speaking of this, she says, the clause is by no means easy to construe, but in my view, and applying the principles of contractual construction, which I've already recited, the parties cannot have intended to exclude from the limitation on liability the breach of the principal obligation appearing in the same clause. It's probably true to say that not every breach would necessarily also count as a breach of the duty of reasonable skill and care. But if it's not true to say that all roads lead to Rome, very many of the roads under this contract lead to Rome, where Rome is reasonable skill and diligence. And there is, in our respectful submission, real compelling force to the conclusion and the reason given by Mrs. Justice Jefford in paragraph 262 of her judgment. My Lord, we are now, I think, at 1 o'clock. I'm happy to carry on if you're any of your brethren wish to ask me a question before the break.
No, we can adjourn now as you wish. We will resume again at 2 o'clock.
Thank you very much.
Thank you very much.